High Court sitting in Abuja has ordered the Inspector General of Police, Usman Bawa Alkali, to enforce its ruling that the current chairman of Economic and Financial Crimes Commission, EFCC, Abdulrasheed Bawa, being taken to Kuje prison for criminal contempt of court. Justice OsazuwaAkonedo ruled that the chairman, Economic and Financial Crimes Commission, is in contempt of the orders of this honorable court made on November 21, 2018, directing the Economic and Financial Crimes Commission, Abuja, to return to the applicant his Range Rover, supercharge, and the sum of 40 million naira. Having continued willfully in disobedience to the order of this court, he should be committed to prison at Kuje Correctional Center for his disobedience and continued disobedience of the said order of court made on November 21, 2018, until he purges himself of the contempt. The Inspector General of Police shall ensure that the order of this honorable court is executed forthwith. The judge, Justice OsazuwaAkonedo, rejected the arguments put forward by the lawyer to EFCC, Francis Girbo, to justify his client's action. According to Nation's newspaper, the court ruling delivered on October 28, a certified true copy, CTC, of which the Nation cited in Abuja on Tuesday, was on a motion on notice marked FCT/HC/M/52/2021 filed by Air Vice Marshal, AVM, Rufus Adeniyi Ohwawo, a one-time director of operations at the Nigerian Air Force, NAF. Ohwawo had, in the motion filed by his lawyer, RN Ojabo, in a suit marked FCT/HG/CR/184/2016, complained that the EFCC declined to comply with the order for the release of his seized property, made by the court in a judgment delivered on November 21, 2018. The EFCC had arraigned Ohwawo on a 2-count charge before Justice Muawiya Baba Idris of the High Court of the FCT in Nyanya in 2016. He was accused of corruptly receiving gratification to the tune of 40 million naira and a Range Rover Sport, supercharged, from one Hima Abubakar of Société d'Equipement Internationaux Nigeria Limited. But, in a judgment on November 21, 2018, Justice Idris discharged and acquitted Ohwawo on the grounds that the prosecution failed to prove its case. Idris held that for the charge to succeed, the prosecution must prove that the defendant corruptly accepted the gift, that he accepted or obtained the gift for himself or for any other person. The judge added that the prosecution also ought to prove that the defendant accepted the gift in the course of, or for discharging his official duty, and that the gift was an inducement or reward. He held that the burden was on the prosecution to prove all ingredients of the charge preferred against the defendant beyond reasonable doubt as required under Section 131(1) of the Evidence Act, 2011. In conclusion, I hold that the prosecution has failed to prove the 2 counts charge of corrupt gratification under S17, 1A and C of the Corrupt Practices and Other Related Offences Act, 2000. The defendant is discharged and acquitted on counts 1 and 2 of the charge. Consequently, the complainant, EFCC, is ordered to refund the defendant his 40 million naira wrongly paid into ONSA recovery account and to return to the defendant his Range Rover Sport, supercharged, forthwith, Justice Idris said, as presented by the Nation's newspaper.